Please rise. The Justice of the Appellate Division, Supreme Court, First Department. Hear, all persons having business with the appellate, please draw near, give your attendance, and you shall be heard. Please be seated.
Welcome to the Appellate Division, First Department. We have over 4 hours of argument time requested today. Therefore, only ask for the time that you need. We are familiar with the briefs and records, and if we need more time, we will continue to ask questions. People versus Sitler, appellant.
4 minutes for appellant and 1 for rebuttal, please.
4 minutes for responding.
4, 1, and 4. Jopal Bronx versus Sayers. Okay, you're the only one here. Do you want to submit it or do you want to argue? Okay, submit it. Ulysses versus Elizabeth T., appellant.
For the appellant, in hearing the 2 appeals, just asking for...
I'm going to have you argue both appeals together. I'm not going to have them argued separately.
Yes. For both appeals, 7 and 2.
And are you here for the child?
Yes, Your Honor.
Okay.
8 minutes, please.
Okay, I'll give you 7, 1, and 7. Epec Technologies versus Interforum. Epec? Interforum?
I represent Interforum BTs and Vivendi. I would request 6 and 2.
And you're here for Bolloré? How do you pronounce it? Bolloré, okay. 5 minutes. Okay, 7 and 1, 6 and 2, and 5. Thomas versus 560, 566 Hudson, appellant.
5 and 2, please, Your Honor.
Respondent?
Your Honor, respondent requests 5 and 2 as well. Is it possible?
Yes, 5 and 2, and 5 and 2. People versus Shakur is submitted. 3350 BW versus Perez, appellant. Respondent?
For the respondent, 2.
2. People versus Holmes, appellant.
For the appellant, 4 and 1.
Respondent? 4, 1, and 4. Armstein versus AX Trading, appellant.
I'm the respondent, Your Honor. I request 3 minutes.
Okay, I will give you 3 minutes. People versus Hilton, appellant.
4 and 1.
4, 1, and 4, and Anonymous versus Anonymous is submitted. Rosario versus General Bear is submitted. State Farm Fire versus Acupuncture is submitted. Federal National versus Araca is submitted. And Troflet versus Buchanan is submitted. So the first case on is People versus Sitler.
Step up.
Good afternoon, Your Honors. My name is Kerry Elgarn. I represent appellant Daniel Sitler. The issue here is whether the crime committed in Nebraska is equivalent to a New York sex offense. It is not. It's equivalent to, the crime committed is equivalent to disseminating indecent material to a minor in the 2nd degree, but that's not a sex offense under SORA. And it's not equivalent to disseminating in the 1st degree, which was the finding by the judge below. The 1st degree offense requires, in addition to what the Nebraska offense requires and the 2nd degree offense in New York requires, is that the material be disseminated with the purpose of importuning, inviting, or inducing the minor to engage.
Counsel, It's undisputed that even though the minor reached out first about getting together, there was basically a cross-offer where he said, come a different time. Why didn't that satisfy the elements?
Because refusing, the fact that the person doesn't refuse an invitation is not the same thing as
But
making
why
an
isn't that-
invitation.
Why isn't that a separate invitation? By basically inviting as to a separate time, place, and manner than was initially brought up, why isn't that in effect its own inducement?
Because the idea is the minors, the minor invites Mr. Sitler to engage in, to pick him up, and what his answer is, can it be later? That's all he writes, and then the next day, he actually texts again and says, forget about it, this is illegal.
I know, but the offense obviously was committed before he texted back and didn't go through with it. Where in the statute does it say anything about who needs to initially initiate the meeting, which is, you're saying that's a
Well,
distinction?
I'm not saying who has to, if the minor had initiated the invitation, and then my client had initiated a different invitation, I mean, it doesn't negate the
Why
possibility.
isn't it a different invitation?
Because he's not inviting him. He's saying, how about earlier? He's not saying, let's have sex. The point, as the cases show, that Foley case in particular, the Court of Appeals says, is what it's about is whether the defendant is luring the minor into having sex with him or into engaging in certain sexual activity with him. And here, there's no luring. The luring, the defendant just sends some communications. They're of sexual nature. Those elements are met, and then it's the minor who says, "Hey, in effect, can we get together?" And the client gives a sort of a conditional acceptance. He's not making a separate invitation. He's not suggesting anything more or different. He's saying, maybe, possibly, and just saying, could it be earlier? So to say that if I'm invited to go out to eat at 6 o'clock and I say, I can't go, how about 5? I don't think I've made the invitation to the person who has invited me out to dinner. I've accepted and said, but it has to be so-and-so.
Would it
It's not a
change?
separate invitation.
Would the analysis change when he changes the time because his roommates would be there at the time that the minor suggested? Would it change the analysis?
No, I mean, that is the facts. That's what he says, that can we change it because my roommates will be there earlier? So no, it doesn't change the analysis.
So basically, you're saying that unless the invitation comes from your client, he has not induced the minor into anything.
Well, then he hasn't invited him. He can't importune. He can't say, had there been other communications in which he was somehow urging the minor to engage in an activity with him, or if there had been, or if he had induced him. I mean, there's 3 words. And I also think that when we're looking at the meaning of invitation, it's used, the 3 words that are used in the statute are importune, induce, and invite. And importune and... Or invite, right. But I'm just saying, in that context, those importune and induce imply much greater activity than inviting does in general, but certainly what happened here, which we maintain, is not inviting at all.
Okay,
It's
let's hear
just-
from opposing counsel. Thank you.
Good afternoon, Your Honors. Saad Siddiqui for the Bronx County District Attorney's Office.
What about his argument that it was the minor who invited him to come, it wasn't him who invited the minor to get together?
Your Honor, the totality of the circumstances just don't bear that out. It doesn't support his argument. I would ask the court to consider the broad context of which the communications originally initiated. The defendant and the child victim met on an app, on a web app, on a cell phone, which is designed for gay singles. And for several conversations that ensued, the defendant was under the impression that the victim was, in fact, a 24-year-old male. But even based on statements that he made to the investigating officer in Nebraska, which was included in the packet to the Board of Examiners, when he spoke to the investigating detective, he admitted that he suspected that maybe this person isn't 24, maybe this person is younger. And once the victim admitted to the defendant that he was, in fact, a 15-year-old boy, that didn't stop the communications. In fact, the communications continued, and they were not of, just one-off sexual discussions. They were very sexualized in nature. The context of all of this discussion culminated in, yes, it was, in fact, the child victim that mentioned the idea of first having this rendezvous. But the defendant's response wasn't, oh, no, we can't do this. It was, that time's not good. My roommate will be home. Let's meet earlier. And then the entire, factual discussion that ensued was...
Counsel, if the defendant had just accepted the victim's offer and agreed to the time and place, he would not have violated this particular statute in New York.
I would respectfully disagree
Well, under that fact, how would he have importuned, invited, or induced the child victim?
Your Honor, because again, it was the overall nature of the contact. It wasn't that he stopped once he knew the defendant, once he knew the child victim was 15. He continued it.
So the fact that he continued, that's the inducing,
Well,
importuning,
in the
inviting?
context that this whole discussion is taking place on a vehicle, on a web medium that's designed to ensure and promote, sexual contacts, hookups, if you will, between singles, right? It wasn't like he was going on this web app to find a pen pal. He went on this web app to find someone to have, at least casual flings with, casual relationships with. And then when he discovered that it was a 15-year-old boy, he continued to have those contacts. And the discussions were of a very, in fact, in some instances, hypersexualized nature. At one point, there's even a discussion in which he is counseling, advising the victim as to how to have his biological brother perform oral sex on him. I mean, again, this is trying to facilitate, advising him how to facilitate incest. So this is not just a simple discussion. And even to the extent that the defendant, yes, changes his mind, first of all, that doesn't happen immediately. That happens the next day. But at that point, the crime is already committed. And
So under that analysis, the defendant's argument that what the defendant did was just a scheduling issue doesn't matter.
fly. No, certainly not when you consider the overall context of this. Your Honor, I would just ask the court to consider one other thing. At the end of the day, also, I think what's even more troubling is that the defendant, at this point in time, when all of this was taking place, was in his last year of medical school. I mean, he's a doctor. He knew, not just from common sense, that he's dealing with a boy. His degree of education made it very clear the person he's dealing with biologically, neurologically, is a child. That is why these laws are in effect. And that is why, based on the underlying conduct, it's very clear that his conduct fits within the parameters of Penal Law 235-22, and it is a registrable offense, and the court should affirm Judge Bruce's finding.
Thank you
Thank
very
you.
much.
The content of the communications, whether the client is a doctor, we're not saying, there's no claim here that the conviction was erroneous. He was convicted in Nebraska. It's equivalent to the 235-21. It's actually a felony here, but the crime that the judge equated it to and the prosecutor sought to have it equated to simply has more elements, and the elements are certainly not met, but the conduct didn't reach that either. And I take the point
Counsel,
that...
you agree that Matter of North provides that where the offenses overlap, that we are allowed to look at the actual conduct in the particular case?
Absolutely. No, that's the central analysis here. Everybody agreed that that the elements overlap, but they're not identical, that there are more elements for the New York offense, and the question becomes whether or not the conduct engaged in, which was basically like rescheduling or suggesting rescheduling and then declining the next day, whether that's an invitation. And I don't think realistically in our ordinary life, and those are the definitions here, there's no statutory definition. In our ordinary life, I don't think we would really consider that to be what my client said to be an invitation. What the minor did was certainly an invitation. Thank you.
Ulysses versus Elizabeth.
May it please the court, Bruce Young for the appellant, Ulysses R. This case, we're asking the court to consider the totality of the circumstances and the evidence that was accumulated. The initial trial was done too hastily. There was a false sense of urgency because the mother says, I've got a job, I'm leaving in 2 weeks. And they try to
What's
get.
wrong with the way that the trial was done, though? Didn't the court hear from the witnesses that were available, allow examination, cross-examination? What was not appropriate about the fact-finding hearing that took place in this case?
Thank you, Judge Kern. In a very hasty, irregular way, which did not create, first, short notice that he's about to move, so that there's not any discovery, preparation. That's why there was a lot of facts that contradicted what the mother said in the renewal argument subsequently. But the urgency of it put so that the sense of urgency with leaving was left it so that there was, I think for starters, the whole case was over before they even decided to appoint an attorney for the child. So it's come back here right away. Right, and two
Counsel,
people. Sure.
I'm sorry.
Sure, Judge Holman.
Can we cut to the chase here a little bit?
Sure.
In looking at the best interest of the child,
Yes.
we recognize, and it's undisputed here, that your client never contributed anything of real substance to the child financially. It was the mother that was carrying the freight. True?
At the time of the record, when as a personal trainer during the end of the pandemic, his business had fallen off and he wasn't there. But he pointed out that he had family resources. There was a family home, a brownstone in Park Slope.
I understand that he was living with the grandmother,
Right.
who was 100 years old, unclear what would happen if, God forbid, the grandmother passed away, and whether he would still have
Did subsequently, and the house is still in the family, and that's where he's there.
Fair enough.
Right.
But the reality is this is also someone that has a history here with 6 other children that he never paid any child support for. So someone that's fighting very hard to be a custodial parent, which is what he was seeking, really never meaningfully contributed to the child. By the way, did your client know about the child's schooling, participated in any of the PTA meetings with the child?
In the very brief hearing that took place, he had, well, first, he raised the child with the mother for 3 years. Then he lived separately. He lives in Brooklyn. She lived in the Bronx. And she took the child to school. Did he remember exactly which day or whatever? No, he didn't come from Brooklyn to bring the child to school. He was there and he had the child on the weekends. But he was a substantial interest. There was no dispute about that.
All the evidence that you put in both at the trial, and let's even put in what you put in the re-argument. What was incorrect or reversible error about what the court decided that it was in the child's best interest to go to Texas at the moment?
I think, thank you, Judge Kern. It's primarily, when we talk about stability in the context of a custody case, I think the thing here is an emotional stability. There's a mother, there's a father. In this instance, there was the extended family, very much involved. The cousins, the aunts, the uncles, the grandparents, all of those were the child's emotional life.
As between the mother and the father, the record seems fairly clear that it was more the mother who was the primary caregiver in the situation and had the day-to-day raising of the child. Under those circumstances, why was it error for the court who heard all the testimony, as opposed to us looking at it on a cold record, to decide that it was appropriate for the mother to be able to move to Texas?
Thank you for that question, because I think it returns to the same issue, is that the child's stability, the emotional life of the child, was the mother and the father, but all of the relatives, everyone that's there. If he returned to the father, he's supposed to return I think finally for an extended time because he wasn't getting all of his access during the past year. The child has all of these relatives here.
Isn't instability the very reason why the mother wanted to go to Texas, where he or she was on a contract for employment, and in Texas she had found something that was more permanent, something that was going to provide both her and the child more stability?
I would say that the economic stability that she placed the child in by moving into a brand new relationship with another man that the child had not even met, it was not even disclosed that his son was living in the home, and what happens if that breaks? What happens if that falls apart? Because she's had a history also of 3 or 4 different relations, and this is the case. In that instance, the extended family is essential, and in her instance, her extended family, she says, oh, I have relatives in Texas. They're in Dallas. It's 5 hours away. It's
All
Oklahoma.
of this testimony, this is what the fact finder does. They take testimony, they hear, they make credibility determination. Why should we disturb that? Which is would be a big thing for us to do.
Of course. And the reason is, if it's the factors, the tropia-type factors.
It's not
given
tropia. We've established it's not tropia because there was no initial custody determination, so we don't apply the tropia factors in this case.
I agree that you don't have to strictly apply only the tropia factors because there was no prior custody agreement. And that's to the credit of the parents that the father had a good working relationship. Even after he moved out of the house, he had a good working relationship. They didn't have to come to court. But when something as dramatic as removing the child from the physical day-to-day or week-to-week relationship that a 5-year-old has with a father, this is something that directly impacts the child's emotional life. It's something more. It requires more.
This happens in every case where a parent is requesting to relocate. It's a serious decision. It's not something I think a court ever takes lightly, especially when both parents have a relationship. But obviously, courts grant those kind of applications, so why not in this case?
I think in this case is because the court did not adequately consider the motivations for the reason. There was no exhaustion. In some of the older cases, like maybe there's been more liberalization that you can let people move all the time, we should let them all move. But we have to recognize that when they leave New York's jurisdiction, New York's court, they don't have the ability to enforce the parties' rights. There was not a very good way to enforce even in the past year. Hopefully that will work out. The good thing is that she's still trying to work with her to be able to have a relationship back and forth, but it has so dramatically affected the relationship.
Thank you. I'm going to hear from opposing counsel.
Good afternoon, Your Honors. My name is Janet Newstetter. I'm from the Children's Law Center, and I represent the child who's now 6 years old. I think Your Honors have definitely zoned in on exactly what the issue is here. The court properly looked at the totality of the circumstances and found, based on all the relevant factors, that it was in the child's best interest to remain in the mother's custody as she had always been. The mother had always been the primary caregiver and had provided for all of her needs, including educationally, medically, and financially, and allowed the move to Amarillo, Texas. In fact, the only reason to have given the father custody would have been because of the impact on his access to the child after the move. Every other relevant factor absolutely weighed in favor of granting custody to the mother.
Didn't the child weigh in favor of going to Texas?
Your Honor, during the proceeding, the child was very concerned about offending either parent and making either parent feel badly. And so she instructed, by the way, there was an AFC, not at the very first appearance, but after that. And the AFC did cross-examine all the witnesses and was present for the in-camera with the child. The child specifically asked the AFC not to state her position on the record. However, the child did state her position very clearly in the in-camera. And subsequently, when the re-argument renewal motion was made, and obviously on this appeal, we have been very open about the child's position, which was, yes, that she wanted to go with the mother.
And on this record, the mother has no quarrel with visitation, correct?
Absolutely not.
In fact, the mother actually went on record saying that the father wasn't a bad dad, relatively speaking, correct?
Correct, Your Honor.
And just so that I didn't miss anything, wasn't there a history of domestic violence?
There was some history of domestic violence. There was never a final order of protection or a finding, but yes, there was, and the mother testified about it. And the neglect case, which was ACD'd, was based on domestic violence. But yes, with respect to what you just said, the visitation was voluntary, it was frequent, and it was voluntary on the mother's part. There was also a lot of phone and video contact. And as of now, that has continued. There has been quite a bit of phone and video contact. There have been visits here, which the mother has brought the child here. And in fact, mother agreed to a 6-week visit for the father starting this coming Monday. So yes, she has been absolutely agreeable with it, and any suggestion that she hasn't is incorrect.
Which means that the child will be exposed to the extended family that your friend has talked about as being so important for the child's well-being.
Absolutely. Given the father's role in this child's life, it's absolutely the kind of situation where, less frequent, more extended visits can be very, very effective. And having that child with him for 6 weeks this summer will give him every opportunity to include her in family events and everything else that he's looking for. With respect to the financial, I think it's really important. The father made this whole pitch about how the mother's sole motivation or primary motivation for going to Texas was a boyfriend. The fact is that she admitted that she wanted to be there in part because of him. But the fact is that she was on, as Your Honor said, a grant-funded, limited time period job, which was going to end. And the father knew this for months. He was not blindsided. It was true that she told him that she had gotten a new job the day after she got it in March of 2022. It then was 2 months between then and when the court decision was made. Granted, that's fast. I find it amazing that people would be complaining about the family court working fast, because it's usually exactly the opposite, and it can be very problematic. So I just find that kind of interesting.
Did the petitioner here, did he know that she was going to leave for Texas, and had he not consented originally to her leaving?
She says that she told him the day after she got the job. I should just step back for 1 second and say that the previous October, November, she had been looking also, because the job was supposed to end sooner but then got extended. And so he knew then, and he knew that at that point she was looking, quote, all over, because it's very difficult to get the kind of job that she had, and there was no guarantee whatsoever she could get one in New York. So he knew since then that she was looking. When she told him in March that she had this job, he initially said he needed to think about it. And she understood him as kind of consenting, as I understand it, because he was talking with her about giving him some of her furniture and things like that when she left. He then said he did not consent, and he filed papers in the family court seeking to stop her from moving directly after that. So can't honestly say that he affirmatively consented, but he certainly knew that this was in the works. He had 2 months from between when he first learned. And I would point out that going back to October, November, when he knew that she was looking, he didn't do anything. I mean, he knew that she was concerned about the time-limited nature of her job. He knew that she was having trouble making ends meet in New York, and that was a major concern of hers. And he did nothing. He did not try to create a situation. He did not try to give her the financial support that would have made it possible for her to feel less stressed in New York. He didn't think about, apparently, what would be involved in his taking the child if she had to leave and he then sought custody to prevent the child from leaving. So to say he was blindsided and it was a short period is really, I think, kind of disingenuous. Also, very, very quickly, with respect to the emotional stability, there's no question the child's primary bonding was with the mother, and that it would have been far more destabilizing to leave her here in New York with the father who had never, cared for her on a day-to-day basis.
Thank you.
And
Thank you.
thank you.
Thank you. In just 1 minute, I'll say it's a pleasure to be back arguing live again after watching you all on camera for a while. I just want to address, I think, the timing and blindsided or not, or whatever it is. It's such a short period of time. The trial judge examined both witnesses, both parties, before even appointing a law guardian, and then gave the law guardian like a back-ended thing.
Didn't your client have an opportunity to testify before the court, to present witnesses to the court, to cross-examine the mother when she testified, and to make his arguments to the court?
He did. At the initial hearing, he complained that his initial trial attorney did not offer certain exhibits, which is why there's, I think, 15, 20 exhibits or something that he, on the renewal motion, that he attached certain exhibits that he was trying to put in.
But he got his due process. He was able to present his case, and he was able to contest whatever was submitted in rebuttal to his case.
In the brief period of time in the initial trial that he did. And I'm asking for the court to consider the totality of all the evidence that was developed both on renewal as well as in the original trial. I just think that the economic factor is not the major factor of the stability. And I think even when there's a
sorry, do you have any more
relocation, there needs to be a...
Okay, thank you.
Okay. Thank you so much.
Epec Technologies?
May it please the court, I'm Sherman Kahn, representing the appellant Epec Technologies Limited. There are three kind of main issues that are before the court right now, and one of them is the application of the economic interest defense. The second is personal jurisdiction, and the third is the cross appeal filed by the dependent.
Obviously, the jurisdiction and the closely related are very intertwined with each other.
They are somewhat intertwined, but I'm going to start with the economic interest and closely related issues. And with the Supreme Court's finding that the economic interest privilege shielded Vivendi and Bolloré from their being liable for interference with the contract that their subsidiary, Editus and Interforum, entered. In finding that they did, the lower court substituted its own judgment for its own inference for the required assumption that all inferences be directed in favor of the pleading party. And the law is clear that for the economic interest privilege to apply, the interfering party must be acting for its interest in the contracting party, not in some other interest it might have. And Epec has pled that based on specific facts.
With respect to Vivendi, it was 100% owner of the Editus parties. So why isn't that congruent? Why aren't their interests congruent, the same?
Because their interests are congruent to the extent that they were acting in the interest of Editus, but if they're acting in an interest that is tangential or different from the interest of Editus, then their interests are not congruent and the exception does not apply.
That divergence that I didn't tease out of your papers, what is the divergence?
Well, they were acting as pled to benefit not Editus, but potential for other purchases of other publishers in the future. That's what they informed our client.
Well, they also said to the plaintiff that, listen, we're going to have so much business for you, cut the prices a little bit, you're going to do better. And so that's obviously in the interest of the Editus parties. Is
It
Editus,
could
by the
be
way?
in the interest of the Editus parties. It's also serving other interests. The law is not that if at all in the interest of the parties that are parties to the contract, that the exception applies. Otherwise, the exception would swallow the rule. It's whether the party is acting for the protection of its interest in that party. Also, there is an exception for fraud or wrongful acts, and we have pled fraud and wrongful acts in several
You're
ways.
making both arguments, that it doesn't apply in the first place, but even if it does apply, then the exception to it applies.
Correct. That's
And why does the exception to it apply?
the exceptions apply. We have pled that, and we put in specific facts as well on this, that Vivendi and Bolloré requested that the Editus employees that were working for Editus at the time that they bought the company trump up or manufacture alleged misconduct or breaches by Epec in order to get concessions from Epec with respect to the contract. The law is clear that lying in order to breach the contract is one of the kinds of wrongful acts that enables that vitiates this particular doctrine. Also, there's
Let me switch topics, because we're going to run out of time and not talk about any of the other issues,
understand.
which obviously are quite central. I know we're discussing the closely related doctrine, and clearly you have a better argument with Vivendi than you do with Bolloré. Why should it apply in the case of Bolloré, who only had 25%, was it 25% interest in the company?
Closely related. There are two elements to closely related. There's whether the we are running out of time. Whether the
No, you still have 2 more minutes.
okay. There's whether the company is closely related in the sense of the corporate relationship. That's obvious with Vivendi. And there's also whether the other party was closely related to the actual facts of the case, and that's where Bolloré comes in. Bolloré's
Don't you need both of those things, though?
and we have both of those things.
Okay, tell
And
me why
it's
you have
actually,
both of those
you don't need both of those things. The cases are in our view, in the disjunctive, one or the other or both are enough. But we've put in evidence that Bolloré has significant control over Vivendi, which has significant control over Editus. But we've also put in significant evidence that an individual who was working for both Bolloré and for Vivendi was orchestrating everything that had to do with this contract for a significant period of time and instructing Editus and Interforum as to how they should perform the contract.
That was Saboni?
I'm sorry?
Is that Saboni? That's the individual you're referring to?
Mr. Sibony, yes.
Okay.
Sir, you don't have a quarrel with the decision to dismiss the counterclaim?
I don't, and in fact, we think
There
that
are no facts to suggest that the projected cost of Epec was designed to misrepresent or lull them into some sense of complacency.
That's correct. There are no such facts, and it's also that counterclaim is completely on all fours with the breach of contract claim, which under New York law means that that claim is not viable. One other point on the fraud or wrongful act exception, we also have evidence that the French tax issue in which Vivendi was asking, withholding money from Epec with respect to
Allegedly paying taxes when there were no taxes due.
in fact, yes,
They
allegedly.
should have been paying your bills.
Instead of paying our bill, and they admitted that that was not in the interest of Interforum or Editus, and it was...
Thank you. You have time on rebuttal.
Okay,
Finish
thank
up
you.
this part.
May it please the court, on behalf of Vivendi, Editis, and Interforum, and I'll start with the appeal as regard Vivendi, and then I'll turn to the Editis cross appeal on the counterclaim. With respect to the Vivendi on the merits, the economic justification defense does apply. It is pleaded.
Sorry, the what applies?
The economic justification defense does apply. The complaint alleges time and again that Vivendi sought to have Editis renegotiate the contract to get better prices on the contract.
Even if it does apply, aren't there at least issues of fact as to the exception to the economic interest?
Well, the exceptions we've heard, there are two of them. One is a purported illegal activity, and the other one is a purported fraud. The purported false statements that are alleged by my friends were not made by Vivendi. They are alleged to have been made by the contracting party.
Isn't there enough in the complaint to say that they were impelled by Vivendi, that Vivendi was in fact behind the curtain?
Well, the complaint says 100% owned, so they're controlling, but that's never been enough for the exceptions. Otherwise, the defense would never apply. For the exceptions to apply, you have to show wrongful means or illegality.
But aren't there specific allegations as to Vivendi and Bellori that they were involved in some of the wrongful means, lying about the desire to acquire additional publishers, fabricating complaints about plaintiff, and various other behavior, which would at least alleges things that would satisfy the exception defense?
Well, the law, I think, is very clear that as to, first of all, is to illegality. The conduct has to be independently wrongful. The only activity that's alleged here is the payment of taxes, and there's no statement that that payment of taxes was illegal. There was what they say is that it was not due. They say in the complaint that it was, quote, wrongful, whatever that means. And in the record, the only thing that is said about that is at R354, where their lawyers say that the payment of taxes would violate the party's agreement. That's not illegal. That's just a breach of contract. And as to the wrongful means, the law is clear that it has to be directed to Editis in this case, not to the third party. Otherwise, if the wrong is directed to the plaintiff, you sue that person in tort, not for tortious interference. That's where the Court of Appeals has drawn the line. As to jurisdiction, if I could turn to that, given the time. First, we think it is permissible to address the merits before, without turning to jurisdiction. There's no case that says that a court has to rule on the jurisdictional objections first. That's not the law. And on the merits, the Supreme Court of the United States has been extremely clear that there must be either consent or purposeful availment. Activities directed by the defendant.
Aren't there now a number of recent cases, though, by the First Department where we have clearly held that you don't have to get into the constitutional minimum context analysis under the closely related doctrine because it's basically an extension of the contractual forum selection clause, and that there's nothing inappropriate with that, where you're so closely related to the contracting party who agreed to be here that it does not offend any minimum context analysis.
There's a case of the First Department, Highland.
More than one case at this point.
Well, there are a number of cases that apply the closely related doctrine. There's Highland, which says expressly that it satisfies foreseeability. In the face of that, there is the United States Supreme Court saying that foreseeability has never been enough to satisfy due process, and that's worldwide Volkswagen.
But there's no case from the Supreme Court that talks about forum selection clause and a minimum context analysis.
Well, Burger King says that a choice of law, that a contract is insufficient. You need to have, unless there's a party is bound by the contract. And here...
Right, but we're not talking about choice of law. We're talking about a forum selection clause, which is a completely different
So we say that's inconsistent with the U.S. Supreme Court. We also say that
so you're basically saying we should reverse ourselves, reverse our
We are,
prior
yes.
decision.
There's no way to harmonize Highland with this case.
No, well, in terms of as to that statement of law, there isn't. But as to the facts, there is in the sense that Highland and all the other cases, the defendant was either around at the time of contracting, which Vivendi was not as the parent, or is a successor to someone who was involved in the negotiation or execution
But are
of
our
someone who
cases
was.
dependent on that distinction that you're making in terms of the analysis?
Well, Arcadia, for example, which was distinguished in Highland, which is by Judge Rakoff in the SDNY, makes that very point in terms of applying New York law. So yes, we don't think that the cases are factually opposite, and we point to Highland for that. As to the cross appeal, if I may, unless there are questions, I know my time is running short, and I don't know if there are questions on.
Go ahead.
The law is clear. The Court of Appeals has stated that when facts are peculiarly within the knowledge of the putative defendant here, Epec, on a counterclaim, that the requisite detail is the pleading standard is lessened. That is the situation here. The facts of the fraud are stated, all the elements.
But they could have done due diligence, couldn't they have?
Well, they could have, but
They didn't.
They did do due diligence, but it was not discovered that the complaint alleges that the projections, which are annexed to the contract, were false and knowingly false, and it's not something that is objectively verifiable in the market because it was a unique product, which is on-demand printing that had never been done before this project. So it is peculiarly within the knowledge of the fraud defendant.
Thank you.
Thank you.
May it please the court, Brad Bobroff, Proskauer Rose, on behalf of respondent Bolloré. So Bolloré's arguments overlap in many respects with Vivendi's, but in a number of ways, Bolloré's defenses here are even stronger. And that's true both with respect to personal jurisdiction and with respect to the tortious interference claim.
Well, why don't you talk about the closely related doctrine as it applies to your client?
Sure.
And why it shouldn't apply
Sure.
to obtain jurisdiction of your client.
So first, with respect to jurisdiction, Your Honor, certainly we think that Justice Schechter was correct to be able to, as she said, not touch it with a 10-foot pole. There is case law in this court and in the Second Circuit and in the district courts that say exactly that. When it is clear as day on the face of the complaint that you can get rid of it, then you can get rid of it and you can avoid dealing with very complicated jurisdictional issues. It's judicial economy and for other reasons. But with respect to, if this court believes that there is still vitality with respect to the closely related test, then Bolloré doesn't meet either of them. So with respect to closely related, Bolloré has to be sufficiently closely related to both the signatory and to the dispute. That's what Tate and Lyle says. And with respect to our connections to the signatory, let's be clear. Bolloré is not the parent company of any of the signatories.
Aren't there allegations that Bolloré controls Vivendi and that both of them were very involved in the decision-making process around this contract and the breach thereof?
So there are allegations that we had control, but there are no facts pled to support those
Do
allegations.
the allegations allow them to get some discovery on the question of personal jurisdiction?
I don't believe so, Justice Moulton. We are the non-signatory minority owner of the non-signatory public company of the parent guarantor of the principal contracting party. We're a twice removed distant affiliate. This court has never before ruled, never, that attenuated relationship was sufficient for closely related purposes.
Haven't we held, though, that there can be closely related doctrine, can be applicable when there's a minority interest? Wasn't that the holding in Universal?
So yes, Justice Kern, that's true. But only when the minority owner is a minority owner in a signatory. We're a minority owner in a non-signatory owner of a parent company guarantor of the ultimate signatory.
But as my colleague stated, based on the particular allegations in this complaint, why shouldn't we allow some discovery as to exactly what the extent of control was or was not exercised by Bolloré over Vivendi and
So Justice Kern, 2 points. One, I don't think you need to reach jurisdiction, as I said earlier, because
Right, but we're asking you questions, obviously.
Yes.
We want to know your answers.
no, so fair enough. They put in lots of additional documents, right? They put in newspaper clippings and things they pulled from the internet. None of that at all shows any control. What do they say? They say that two folks with the last name Bolloré happened to sit on the board of Vivendi, of Vivendi's 13-member board. Yes, Justice
I'm
Shulman.
sorry.
Please.
As my colleague posed earlier, Michelle Saboni, I don't know if I'm pronouncing correctly, was not only Bolloré's purchasing director, but it was Vivendi's chief value officer who was responsible for managing the editor's defendant's performance on the agreement during this period. That's a guy that's wearing two hats in the whoop and wharf of the entire process here, and with the ability to have given instruction, withhold those payments to Epec because we're going to need them for the taxes. True?
So, Justice Shulman, 2 points. One, they have to show both that we are closely related to the signatory and that we're closely related to the dispute. With respect to Mr. Siboney, yes, he works at both of these companies. But the evidence that they put in his LinkedIn page. If you look at his LinkedIn page, at Vivendi, his role is to be, he is in charge of Vivendi's subsidiaries' relationships with their vendors. At Bolloré, he's the head of procurement. Just because he handed a Bolloré a business card once, or once used a Bolloré website, a Bolloré email account, that does not mean that there are sufficient allegations here to pull my client into this case.
So maybe, as Justice Moulton suggested, discovery is needed.
Justice Mendez, I hear you, but I'm not trying to get around your question, but that's with these complicated issues about jurisdiction. If you can go right to the merits and it's clear on the face of the complaint, there's no reason to have motion practice over personal jurisdiction, to have discovery over personal jurisdiction, to take the court's time for oral argument when you can just look at the face of the pleadings. Justice Schechter said this wasn't even a close call.
You had a chance to make that argument.
Yes.
So thank you very much.
Thank you.
I know you're pressed for time, so I'm going to keep this as short as possible. Mr. Levy said that there was no statement of illegality with respect to the French tax issue. That is not consistent with the record. I'm just going to read from R409, which is the declaration from Epec's French counsel. These acts by Vivendi inducing its affiliates to divert payments duly owed are not business as usual or standard conduct in France, and certainly a situation I have never experienced before in my 20-plus years of experience as a tax lawyer. Rather, they are wrongful acts under French law that would be independently actionable in court and have harmed Epec Malta. I don't think you can be clearer that there was a violation of law. As the court pointed out, the Highland case is the law of the First Department. There have been several other cases since Highland. This whole issue about minimum contacts is really a red herring because Highland is essentially saying that the closely related doctrine is a species of consent. And if you have consent, you don't need to go through the minimum contacts analysis.
Thank you. Thank you.
Okay.
I think I have time on my cross appeal, but as my friend didn't address that, I'm not sure.
I'm happy to address it.
No, I'm not, but I don't, unless the court has questions, I don't have anything to.
Okay.
Thank you.
Thank you very much. Thomas versus 566 Hudson.
Good afternoon, Roger Sacker, Newman Ferrara. May it please the court. Obviously, we've seen Burroughs. We don't agree with it. I'm not going to get into, why we think it violates Thornton and Grimm and Condonson and all the other precedent the Court of Appeals has provided us. But I do want to point out one thing that is particularly troubling in the context of this case with that determination, and that's the issue of base date. In order to demonstrate a fraudulent scheme, you have to show that the to get the default formula, you have to show that the fraudulent scheme tainted the rent on the base date. Now, often, the tenant that is making the claim, including several...
But you can't ascertain what the rent would have been on the base.
You can't ascertain what the rent would have been. And this is where this reliance issue comes in. Because you have to have the tenant in occupancy on the base date or before the base date. They're the ones who have to say who have to stand up and testify and say, I relied on the landlord. Well, often, that's a different tenant. You don't know who they are. All the records are in the landlord's possession. That tenant may be dead. They may be complicit.
In this case, is there an issue about whether we could ascertain what the rent was on the base date 4 years before?
You could ascertain what the tenant was paying, determining...
According to what the Court of Appeals said in Casey, isn't that really it? Like,
there's a difference.
If we can ascertain what the base rent was 4 years ago, then we don't apply the fraud formula. Isn't that what it says?
Here's the difference, and this is key. This was my second point. I'm so glad you brought it up.
Happy to oblige.
The base date rent in Casey was 2007, right? That's what Casey says, October 2007, 4 years before the filing of the complaint. That base date rent was not tainted by fraud because they were relying on DHCR, right? We all know this.
But, so
Here's the
it
difference.
sounds like you're trying to make a distinction between post-Gersten and pre-Gersten. I think they've already said that's not going to fly in Casey.
No, they did
is
not. You read Casey. They did not even cite Gersten. So why should, and this has always troubled me, why should Roberts be entitled to deference? That we're saying, oh, you deregulated after Roberts. I mean, this came up in an oral argument last week. But Gersten's not entitled to deference? Landlords such as this landlord are permitted to ignore this court in perpetuity and continue to put in their leases. We're not taking a J51.
And you're saying there's not, I'm sorry, go ahead, go ahead.
Mr. Sacker, what's clear here is if there's an overcharge, your client will be heard, and in that sense. The question is whether the fact pattern here, when you're dealing with the application of Roberts to the deregulation and the re-renting, et cetera, and the lack of registration. Regina and Casey have made clear that the fact pattern here, putting aside certain other nuances, and I know you've made that clear in the record in terms of failing to acknowledge that you are subject to rent stabilization in these leases, you were taking J51 and wrongly saying you were not subject to rent stabilization, I get that. But anything involving a Roberts-type issue, Regina and Casey have made clear that that doesn't squarely fit within the fraud-type analysis that would compel, as a matter of law, on summary judgment, the default formula.
I would respectfully disagree with that because they haven't talked about post-Roberts deregulations. They still have not had a single case in front of them that dealt with post-Roberts deregulations. None of them.
But haven't they said that you need to prove fraud?
Well, this is where we get into what I mentioned that I wasn't going to touch on, but I'll touch it. No, Regina footnote 7, and Justice Schulman and I talked about this last week, sets out the elements of fraud, right? What is Regina footnote 7 citing to? Thornton, Grimm, and Condonson. And in none of those cases could the tenants have made a common law showing of fraud. In fact, in Condonson, the court specifically says the tenants aren't making a generalized claim of fraud. They're making a claim of fraud within the context of Grimm. And in Grimm, the tenants knew about the illegal conduct.
Isn't that part of why the Court of Appeals was making, and it's not the best decision, Casey, I will acknowledge, but isn't that what they're saying, that if you can look back and you can't figure, they're not saying it there, but you can't figure out what the base rent is because of the fraud, then that's when you apply the default formula. But if you can look back, which you usually can in these type of Roberts cases, and you can see what the rent was 4 years before, then you don't apply the default formula. Isn't that what they say in Casey?
But this gets us to that distinction.
And that has nothing to do with pre or post Gersten or pre or post Roberts. It's saying in these type of cases.
Except here's the difference.
How do we not follow
in
that?
Casey, the base date rent wasn't tainted by anything. The landlord didn't do anything wrong. Here, you have the base date rent is
That's not,
2015.
that's not what the Court of Appeals is talking about in their decision. They're not making the distinction that you're trying, I mean, I'm looked at it.
Because I know you looked at it because we've talked about it before. If they made that decision, if they said that post-Roberts deregulations or post-Gersten failures to register are fraud, it would be dicta. And they didn't say it explicitly because that issue wasn't before them. Because Casey was not a post-Roberts deregulation and it wasn't a post-Gersten failure to register.
Are there any more questions that anyone wants to ask?
Thank you.
Okay, thank you.
Thank you. May it please the court, my name is Stacy Feldman and I represent the respondent cross appellant 560-566 LLC.
What about his argument that the Court of Appeals in Casey, it wasn't a post-2009 case?
Well, many of the apartments here were not post-2009 registrations, deregulations. They were pre-Roberts deregulations, including 5 of the 6 apartments that are the class representatives in this case occupy. So those are all pre-Roberts cases. As to post-Roberts or Gersten, post-Roberts deregulation or post-Gersten failure to re-register, there simply is no rule of law from this court or the Court of Appeals that states that that is per se fraud. And even Montero stated that the failure to re-register
Counsel, here we have leases that misrepresent that J51 was not applicable to the building. There are several of them in the record. Isn't that evidence of at least scienter and falsity and material misrepresentation of fact? So it's a long way toward getting toward fraud when you look at those leases, it seems to me.
In Tribs, Your Honor sat on the panel that determined just the opposite. That Your Honor said that in Tribs.
In Amchin, did we have leases like these ones? You talking about Amchin?
Yes. Leases that stated that they're not deregulated, that they're not subject to rent stabilization, that in the event there's a J51, tenants would be notified. They're identical. And in Tribs, the court said, first of all, the court said because there were no affidavits submitted by any tenant, that was fatal for a summary judgment motion.
There was no showing of reliance.
There was nothing, as Your Honor, as you, Justice Shulman pointed out in the Najero case, without an affidavit, there's no scintilla of evidence of any reliance by any tenant. The court below stated that there was no evidence of any overcharge, that there was no evidence of the J51 period, that there was no evidence of the tax records. The court held in abeyance every aspect of summary judgment, but then incredibly went on to say that summary judgment should be awarded on fraud. But the fraud has to do with the overcharges, the claims made by tenants, affidavits by tenants, reliance by tenants, injury by tenants, and scienter. And none of that was presented. So the court jumped the gun and did exactly the opposite of what this court did.
Counsel, in Ampen, which I'm reading right now, didn't we explicitly say that the case differed from other cases because the owners affirmatively misrepresented in those other cases the rent stabilized status? I thought in Ampen that was a factual difference between other cases. So you're saying we had leases in front of us in the record in Ampen, but we said this in our decision?
Your Honor, actually, in Tribs, the court did also say that...
I'm talking about Ampen, not Tribs.
I understand. The court cited Ampen in Tribs and said that in Ampen, that the court didn't have Ampen before it, and that Ampen had stated that a failure to re-register and a rent increase alone are insufficient to...
I know I'm talking about leases, counsel, and you represented to me that the record in Ampen had leases like the ones here. Is that correct?
No, I said in Tribs, Your Honor.
In Tribs, okay. I'm
Tribs
sorry, I thought we were
decision
talking about
that
Ampen.
Your Honor
Okay.
had recently
What
determined.
happens when a landlord, there's evidence in the record that the landlord has affirmatively misrepresented that the building is not subject to J51 when it is subject to J51? You're saying that that's not enough for fraud?
That is not enough.
Why not?
Also in Najero, well, because you have to prove intent, and...
What else would the other intent be when you're saying that the building's not subject to J51 and it is?
It's not saying that it wasn't, it said you'd be notified if it is. But the point being that there is no per se rule of fraud. If you were to hold that...
Are there any facts or any circumstances under which, after Casey, that a tenant could prove a fraudulent scheme to deregulate?
I'm sure that there may be. However, fraud should not have been determined by the court at this juncture, just as this court held in Tribs, because there was not sufficient showing of summary judgment, and that's what the court held.
So, I'm sorry, so that, assuming it was on remand, for the sake of discussion, and you're going to trial, Mr. Sacker's client could get on the stand and give direct testimony of reliance and all the different elements of common law fraud, which have been in our jurisprudence for time immemorial, and which Regina made clear is what we're dealing with, common law fraud in the context of this kind of issue. They could prove their case in that context, true?
It's possible, but first they have to establish the elements of fraud. They haven't even pled them in this complaint. It's not a verified complaint, so it doesn't substitute for affidavits, again, as this court held in Tribs. This court is pretty much on all fours with Tribs, other than the discussion of the fraud. And the fraud that the court was discussing in this case, the court held that the rent registrations for 560 Hudson were unreliable or constituted fraud based on the Casey decision from this court, which was overturned by the Court of Appeals. So that falls by the wayside. The court said that the fraud in the other buildings was different, but it didn't really say how it was, other than to say that on certain registrations that predated these tenants, that there were vacancies, but their leases, and all of their leases have not been presented for the entirety of their tenancy, but those leases said vacant, VA, on the registrations. But 3 of those demonstrate, I just did a random sampling, and 3 of those showed that they weren't vacant. Because when you're looking at registrations, the date that you're registering or the information is from April 1st of that year. The leases were subsequent to those dates. So the registrations would say vacant, and they probably were, because leases were entered in that same month, April, and tenants didn't take possession until May. So there was nothing to establish to the court that there was any overcharge or that there was any fraud.
Thank you. You're going to have time to rebuttal.
Thank you.
One quick point and then one quick plea. Justice Schulman, my clients could get up there and say, yep, I relied. And you know what? In often cases, it wouldn't matter because they were not the tenants prior to the base date. You have to show, if it's a fraudulent scheme obtaining the rent on the base date, you have to show the fraud happened in more than 4 years ago. And this is why there's such a problem with this base date argument. So that they certainly could. And you know what? They could still lose. And then my plea. So, we are asking that boroughs go up. Let's get this cleared up. Let's finish J51. We're going to ask that all of the cases that we've argued, all 5 of them over the past few months, we will be filing motions for leave to go up. We hope one of them does. We hope it's this one or any of the other 4. And with that, unless there's any questions, we'll rest on our briefs.
Thank you.
Thank you.
Thank you. So, Your Honors, all of these tenants were actually in possession, to my recollection, based on the record, on the base date. The base date is September 12, 2015. We kind of glossed over Mr. Sacker's appeal, and that was one of the issues in his appeal, and now he concedes based on Wise that the court properly changed the base date. As far as,
Is that correct, though? Just on that point, shouldn't we adhere to your stipulation?
Well, the court, Your Honor, it's for this court to decide. So if we stipulated otherwise and the court wants to hold us to that, then that's what this court will decide. If the lower court felt that it should be amended, I think that the court has the opportunity to do that as well. But I'll rely on my briefs with regard to the summary judgment again. But I do just want to say that last week during Najaro, Mr. Sacker said to this court, not this particular panel, but to this court, that Burroughs was being described as a judicial straitjacket. And Justice Schulman took homage with that and had his response. But I will say to you that if you hold that there is per se fraud just for a failure to, just because a landlord treated an apartment as deregulated and didn't register it, that would be a judicial straitjacket. That would remove all of the common law elements of fraud that the Court of Appeals has now confirmed in Casey and stated in Regina that tenants need to prove. And Every landlord should still be given the opportunity to prove scienter or that it didn't exist, and every tenant must prove the elements of common law fraud. If you say otherwise, then you will do away with the elements of common law fraud, and it would be in contradiction to the Court of Appeals decisions. Thank you.
Thank you. 3350 BW versus Perez.
Good afternoon. If it pleases the court, I'm Mark Altschull for the appellant. This is ordinarily a very vanilla summary judgment in lieu of complaint case, but for the fact that there's the New York City Administrative Code 22-1005, which was found by Judge Rodney Abrams in the Southern District to be unconstitutional while this appeal was
that
being...
That happened, but what about Rosangela Perez's affidavit, too? We got to talk about that.
Okay. What happens is she does not specifically say that the store was closed. She does not say that it could not operate because it was a
She
pharmacy.
says your ledger is incorrect. That's not enough.
That's not enough. She has to say where it's incorrect.
Counsel, the ledger, was it made for the purposes of litigation?
No, this was generated
prepared-
from their computer system and put in as an exhibit.
I'm a little surprised by this case because I've obviously seen thousands of these type of cases over the years, and
Yes.
I've never seen a plaintiff move for summary judgment in lieu of complaint. In every case, you move for summary judgment on liability, and then it goes off to a referee to make a determination, and the ledger is just one of the pieces of evidence that you'd present before the referee to determine what the rent should be. Normally, when you're talking about an instrument for the payment of money only, you're not talking about a ledger. You're talking about something that's unambiguous and clearly defined, and it sets forth an obligation. A rent ledger is your document. Your client produced it. So why, before we even get to whether they raised an issue of fact, why would that be an appropriate vehicle?
Well, there are other cases of landlords suing on guarantees and being awarded summary judgment in lieu of complaint, and I cite to them.
But once the other side says, hey, I have an issue with this ledger, I don't think it's accurate. It does show that there was a balance on 12/19/19, and we were fully paid up with rent at that point, and that was not correct. Why isn't the tenant then allowed to go to trial on that issue, or go to a referee on that issue?
Then, as you suggest, there should have been an award of liability at that time.
Right, but the problem is you didn't move that way. You moved for summary judgment in lieu of complaint, which is an all or nothing kind of situation. Either you get everything or you get nothing. You took away from the court the flexibility to say you win as to liability, but you have to go off to an inquest as to damages because of the way you moved in this case. So if the court says, well, there is an issue about this $19,000, even though I think maybe you're right about liability and everything else, the only thing the court could do is what it did do, which is deny summary judgment in lieu of complaint, let them answer, and let the case proceed.
Well, I still think that the defendant was under an obligation to say something more than what they said, and that's what the case law is on summary judgment.
Why does the defendant, why does this ledger, which is your own document, in a lot of these cases, there's a note, both sides signed it, there's a clear obligation. Right. That's not what a ledger is. A ledger is a document created by the landlord. Doesn't the tenant have the right to say, this doesn't accurately reflect the payments that have been made, and I want to put you to your proof?
Well, I think that in cases such as a note and their payments, their banks go and put in what their payment record is, and that's usually sufficient. That's my experience.
Okay.
Thank you.
May it please the court, I'm Brian Hoke. I represent the respondent in this. I think your honors were very correct. The ledger.
Let me ask you a question. Why is this affidavit enough? I mean, it's a very conclusory, short affidavit. It says we paid everything up to COVID. There's no rent payments, there's no checks, there's no anything. It's just a bald, conclusory statement. Why is that enough?
Because there were no bills either. In other words, all the landlord did was show a computer-generated ledger without any proof that they had ever billed the tenant for anything for this amount. In other words, this was just their inside document. So all the tenant can say is, we paid everything that we were supposed to pay. That was it. There were no outstanding bills that the landlord showed them that were outstanding. That's really what it came down to. And that was their position. Whatever they had been billed, they had been paid. There were no bills outstanding. And yes, I know it's a very short statement, but that's what the facts were at the time, as far as they understood. I can go into some of the other issues that were raised on the appeal in terms of their being able to use the store as a pharmacy, which is true, that the lease did provide for that, but they were not using it as a pharmacy. There was no proof that they were using it as a pharmacy.
The COVID
Using
issue's
it-
out now because the administrative code was held to be unconstitutional, so.
That's true.
So that issue's out.
That's true.
So really, you don't have a defense to most of what's being sued. The only defense that you really asserted is to that $19,000.
Although we could be back in a few months after, the second, because it is up it has been appealed to the Second Circuit, so it could happen. So yes, Your Honor. If there are any other questions, other than that,
Thank you.
thank you.
Well, there's no dispute then that they didn't pay during COVID, and there's no obligation of the landlord to send a bill. They have an obligation to pay. If that pleases the court, thank you for my time.
Thank you. People versus Holmes.
Good afternoon. Naila Siddiqui for Appellant James Holmes. A sentence of 16 to life is a substantial sentence that accounts for both the seriousness of this offense and my client's prior criminal history, but would also recognize the powerful mitigation given his dramatically reduced level of culpability. At the time of
his serious mental health diagnoses, and they were serious, that they were before the sentencing court.
They were before the sentencing court. However, this was a negotiated plea, and the plea and sentencing judge were different. The plea judge, when he accepted the plea, declined to accept a appeal waiver because the sentence of 18, presumably, he did say this is a significant sentence, so acknowledged the seriousness of or the significance of the sentence, presumably for potential appellate review. So it was before the sentencing judge. However, it was still, it's a 16 to life sentence is still substantial.
But in your brief, not your brief, in the brief, one of the briefs I read, the current sentence is just 2 years less than the absolute minimum sentence for a Class B felon, correct?
It's 2 years, yes,
Less.
it's 2 years less than a Class B.
And he was sentenced to 18 to life, and you only want 16 to life. You want to just reduce by 2 years.
Yeah, this modest reduction, because of the nature of the sentence, it is a life sentence either way, but it would allow him to go before the parole board and demonstrate to the parole board 2 years earlier, when he would be 68 years old, that he is not a threat to public safety, that he has rehabilitated, that he has managed his mental health. And so that's all. It is a very modest request, but it is significant to a person who will be 68 at the time, has significant mental health issues, and would still be serving a lifetime of parole. If the court has no further questions, I'd like to reserve the remainder for rebuttal.
Thank you.
Good afternoon, Your Honors. Elizabeth Schmidt for the people. May it please the court. As Your Honors pointed,
We understand that it's a serious crime, but counsel's argument, 2-year reduction which is all they seek, not that substantial, given the defendant's mental health history. What do you say to that?
Your Honors, I say, as this panel has already pointed out, that that information was before the sentencing court. The sentencing judge even said that she had read the PRS reports that's fully outlined the defendant's mental health history. The court imposed this sentence, clearly believing that this was the correct sentence here. And so I believe it was...
The court, however, may have thought otherwise when it refused to require a waiver of right to appeal, correct?
The court did refuse to require a waiver of appeal, but still instituted the sentence, Your Honor.
Those are two different courts, right? There were two different judges. There was an appeal, there was a plea judge, and then there was a sentencing judge, correct?
I apologize, Your Honor. I briefed this case in December.
I think it's right. I think it's Justice Dwyer took the plea and Justice Whitner was at
Okay, I would defer to you, Your Honor. I apologize. I don't know that off the top of my head.
But in any event, the defendant was a potential exposure to 20 to 25 years with the maximum of life, correct?
Yes, that's correct, Your Honor.
So this was a negotiated reduced plea of 18, correct?
It was, Your Honor.
And we can't lose sight of the fact that it was a horrific crime. He stabbed his roommate 26 times over a glass of water or something to that effect.
Yes, Mr. Holmes stated that he was annoyed by his roommate. They were both in, I believe, supportive housing at the time. He was annoyed because around 5:40 or so in the morning, his roommate had gone up to their shared kitchen to get a glass of water or some drink, and the defendant went into his roommate's bedroom, stabbed him 26 times.
And he actually admitted it to the police when he walked in.
He did, Your Honor. He caused a collapsed lung, a severed artery, a deep gash to his face.
We know what the facts are, and there's no doubt that this was a horrific crime. But question: Could the court have simply offered less than what the people were offering this defendant, as long as it was within the parameters of the 15 to 25 to life?
It's within 16 to 20 years to life. Your Honor, I think ultimately this was still the correct sentence to receive.
No, but could the court have offered less? The plea court, that is.
Off the top of my head, I apologize. I don't know, Your Honor. I apologize. But in any event, I would again like to note the severity of this. I would also like to note that in other cases where this court has reduced a sentence because of someone's mental health history, those have been cases where the defendant has managed his mental health for a long period of time, or has had no prior contacts with the criminal justice system. And Mr. Holmes, by contrast, has a long history of felonies. He was sentenced as a violent, persistent felony offender. If there are no further questions, we ask that you affirm.
Thank you.
To your question on whether, if the court reduced it to 16 to life, the prosecution could have simply withdrawn the plea and there would have been no plea and he would have had to go to trial. So if the court were to do that, that's likely what would have happened. Again...
What was the top count here?
I'm sorry?
What was the top count?
The top count was attempted murder. It was a B felony. He pled to a C, violent. Again, he did go and report the incidents to the police. He did accept responsibility. And while the behavior was irrational, he was in the throes...
He did go to the police. He went with the knife, but he also said something to the effect of he deserved it.
Yeah, he was not of sound mind at the time. And because of the nature of the sentence...
You're not suggesting he was insane.
At the time he took the plea, the defense attorney was about to give psychiatric notice and for the defense, but he was able to take the plea. The judge accepted the plea, so there wasn't an issue. So there was potentially a viable psychiatric defense.
So if that's true, then you could have appealed.
I
mean, there was a waiver of appeal.
There was no waiver of appeal.
Well, you could have moved to vacate the plea. I mean, there were a lot of things you could have done if you felt the defendant would just was coerced or somehow wasn't of sound mind.
I'm not arguing that he was not of sound mind at the time he took the plea. I'm arguing that he was not of sound mind at the time that he was, at the time of the incident. so when the incident was in May, he was incarcerated for about 3 months when he took the plea. So I'm not arguing that that he was.
So that's my point. My point is if he was not of sound mind when he committed the crime, that's what you're saying, then there would have been an insanity defense. Why plea?
Mr. Holmes wanted to take a plea at the time. They were giving psychiatric notice to go forward. However, he opted to, and the judge asked him all the questions. There's nothing in the record at the plea that I would have been able to make a claim that it was not a knowing involuntary plea. So that is why the only thing before this court is whether or not the sentence is excessive.
Thank you. Armstein versus AX Trading. It's only you.
Thank you, Your Honor. Zachary Cooperman of Abrams Fensterman for the respondent. The court below granted partial summary judgment on liability, and denied summary judgment in part. Not only should this order be upheld and to the extent appealed from, actually, the whole motion should have been granted.
That's not before us, obviously.
I understand, Your Honor. And really, appellant's entire appeal has not been preserved. Appellant's scant arguments below failed to preserve almost all of the arguments they raise on appeal, including they now claim that there was no compliance with the commercial division rule. Not only was this not raised below, this is not a commercial division case. The commercial division rule doesn't apply, and in any case, the court below has the discretion to either allow or require or not require a statement of material facts. I want to emphasize for Your Honors that when a defendant opposes a plaintiff's motion for summary judgment based on an affirmative defense, the defendant has the burden of establishing each element of an affirmative defense, making a prima facie showing of each element of affirmative defense. The defendant can't simply oppose a plaintiff's motion for summary judgment based on, for instance, equitable estoppel by only raising one element of equitable estoppel. And they barely have raised any issue of fact, much less any issue of fact that would require denial of the motion or vacature of the order.
Thank you.
Thank you.
People versus Hilton.
I'm not sure what my answer is.
I was going to say, don't you have an adversary?
There's supposed to be an adversary.
Good afternoon. May it please the court, Svetlana Kornfein for appellant Keenan Hilton. The subject over which the Special Narcotics has jurisdiction is a narcotics indictment, as that term is defined in the Judiciary Law 177B1. Narcotics indictment is an indictment charging the sale or possession of
Counsel,
narcotics.
Then there was a superseding indictment, and that's where I think you run onto the shoals of whatever. In other words, you have to talk about the superseding indictment.
Well, no, because the Special Narcotics never had jurisdiction to begin with, and the judiciary.
In addition to the jurisdiction of indicting on narcotics cases, can't they also indict on charges that are joinable?
Yes, that's a different issue.
Well, is it? I mean, in this case, the gun possession is arguably joinable with the narcotics possession.
Well, but there are two different types of joinder, and there are two separate mechanisms for joining cases together, and they've got separate statutes that provide for each one of them.
But wasn't everything from the same transaction?
Yeah, but that's just the joinder rule, okay? We're not disputing that joinder was proper here, okay? It was the joinder of defendants. They joined a non-narcotics case to a narcotics case. What we're arguing is that the statute which I just read, that the prerequisite is the possession or sale of a narcotics drug and any other offense that's properly joined, that refers to the joinder of offenses. It doesn't say and joinder of defendants who don't have a
Are you saying that if they get it
non-narcotics
wrong in the first, if you're correct, say we take that as a premise, that if they get it wrong in the first indictment, then they're out of luck?
Yes, because in the statute, 177.
So the indictment can't be superseded?
No, because they never had jurisdiction to begin with. So they don't have the jurisdiction to represent that case before a new grand jury. That's in the statute, the 177D3.
So that the case was represented or was a new case presented?
But it's the same case. It's the same case to which they just added a narcotics charge. So,
Well, narcotics charges and additional weapons charges, right?
but they didn't have the authority to bring that case to the grand jury because it was a gun possession case. And so they never had jurisdiction over it. And so because they never had jurisdiction over the case, they couldn't present it to a new grand jury. It had to be, from the very beginning, they had to have jurisdiction over the case. It had to be a narcotics indictment, as that term I just defined, and it wasn't. And they couldn't acquire jurisdiction by just adding it on to a case that was properly within the jurisdiction of the special narcotics. And so it's for that reason that the superseding indictment is a null instrument. And again, the statutory definition of narcotics indictment, which I think is very important because this case really does turn on statutory interpretation. And the statutory interpretation is the joinder of any other offense. It does not say joinder of defendants. And I think that's what makes it clear that the initial indictment, which I hope you all agree, was defective, and because they lacked jurisdiction, they could not represent it. Thank you.
Thank you.
Good afternoon, Your Honors. Michael Tarpon for the people. Your Honors, the defendant's claim is academic because there was the superseding indictment. The indictment the defendant challenges is not the indictment he pled guilty to. And there was no jurisdictional basis in the second indictment on the first one. The basis of the superseding indictment was, as with any superseding indictment, a separate grand jury presentation. In this case, it was to a different panel, a different grand jury. 9 months later, they represented the entire case. So there was no connection between that second one and the first one. In fact, Your Honors, the defendant in the first indictment, when it was pending, he had moved to dismiss that indictment on the ground that didn't charge him with a narcotics offense. Had that motion been granted and the indictment been dismissed, there's nothing that would have stopped the people from going into the grand jury again and representing the case and charging him with a narcotics offense. And that there would be, defendant would have no ground to object to that. So that, I think, demonstrates that there is no, that's essentially what happened here, since they represented. So that demonstrates that there's no jurisdictional connection between the two. So the defendant's claim is academic. It's also waived and forfeited and meritless for the reasons we submit in our brief, but I submit that you could dispose of the entire case on the fact that it's academic. If there are no questions, we rest in our brief.
Thank you.
Again, the statute provides that the special narcotics must have jurisdiction from the very beginning, and they couldn't fix this jurisdictionally defective case by adding a narcotics offense, which is what they did after it was brought to their attention by counsel raising the motion to dismiss based on the jurisdictional defect. They went and they obtained the narcotics charge, and then they represented it. And our position is that they did not have the jurisdiction. The Kings County could have done that. They could have prosecuted the entire case. The case could have been divided. Kings County could have done Mr. Hilton's case. New York County, the special prosecutor could have taken care of the co-defendant, but the New York County Special Prosecutor's Office did not have jurisdiction over Mr. Hilton's Kings County gun possession case. Thank you.
Thank you.
Thank you.